Hi, my name is Ben Humphreys, and I'm an attorney in Elizabethtown, Kentucky. I practice law with Lewis Graham, and he and I focus on elder law and estate planning. Today we're going to talk about one of the common threats to your estate plan, and that's not having a healthcare power of attorney or a living will in the event that you should have an accident or illness. Now, if you don't have a healthcare power of attorney or a living will, that means that your family will have to file for guardianship in order to have somebody appointed to make your healthcare decisions. And so Lewis and I, what we do for our clients is we help them draft healthcare powers of attorney or living wills. And in that document, it tells what your wishes are, what you want to have happen if you should have an accident or illness. If you're in a terminal, if you have a terminal illness or irreversible coma, then it says to everybody that surrounds you, your doctors and everybody else, what do you want to have happen? And you've got to have that in place because you never know if something might happen. You never know when that car wreck might happen and you have to go in the hospital. You never know when you're going to get sick and you're going to be in the hospital and you're not able to make the decisions anymore. And so that's one of the things that we see is one of the biggest threats to people's estate plan is not having a living will or a healthcare power of attorney in place. And so if you don't have one, you have to understand that if you have that accident or illness or if you have that car wreck, then your family's going to have to go down to court and file for guardianship. And that's a very long and costly situation for your family, and it's something that you want to try to avoid. And so we recommend that you do a healthcare power of attorney, and in the power of attorney you name a loved one to make your medical decisions if you're not able to do so. We also recommend that you have a backup. It's very, very important to have a backup just in case the first person that you name can't carry out your wishes because something's happened to them. And then finally, the most important thing I also want to address is what we call the second bite of the apple. Most healthcare powers of attorney and living wills simply state that if I reach terminal illness or irreversible coma, then my family can go ahead and pull the plug and let me die naturally. Unfortunately, it doesn't say that they have to pull the plug. And also it doesn't say how long are you to be left in that situation, that terminal illness or irreversible coma situation. And so what we do in our documents, our healthcare powers of attorney is, we go ahead and have that discussion with our clients. If you reach terminal illness, if you have an irreversible coma, if you're in that situation, and we know that you want to have the plug pulled, and we know that you want to be allowed to die naturally, but exactly how long would you want to be in that position, that situation, before you deem that to be too long? Most people believe that they only want to be in that situation a very short time. Other people would like to give their family the opportunity to get second opinions. They would like to give their family some time to make sure that all of your loved ones are in town, to make sure that everybody gets their chance to talk with you or talk with family before any major decisions are made. And so we put a language in our healthcare powers of attorney called the second bite of the apple. And that second bite of the apple explains how long would you want to be allowed to stay in that situation, that terminal illness or irreversible coma. And you may say, well, why would I want that? Why should I just have my document say, I just want the plug pulled and let that be it? And the reason is because most documents don't say exactly when the plug should be pulled. It just gives your agent or power of attorney the ability to pull the plug, and it doesn't say when. And so if you don't have a timeline in place and you reach a terminal illness and your family's having a difficult time determining when or how to pull the plug, if you've got language in your healthcare power of attorney that says, if I'm in that situation, don't let me linger longer than 30 days, let's say, then your family has clear instructions on what you want to have happen. They know your plan, and that's the main thing that we always talk about here at our law office is we want to create a plan that's your plan, and we don't want to use the state's plan. We don't want to use just a plan that is given to you free at the hospital, like the living wills you might get at the hospital. They're free, but they don't have your plan, your specific plan in the document that sets forth what you want to have happen if you reach this situation. So that's one of the major threats, one of the common threats that we see for people when they're doing their estate planning. Just making sure that you have a healthcare power of attorney or a living will in place. And that's always a good first step to take when you're looking at doing estate planning. Thank you, and we're going to continue doing these short videos to try to help the people in our community understand what are the threats to your estate planning.